this live discussion about the new Title IX regulations that the Department of Education just issued this past Wednesday. I'll start this off by apologizing. We're a little bit late. We had some technical issues with the broadcasting, but we are here now, and we're really glad to have you. I have two amazing fellow discussants here, my colleague, Jennifer Braceras, who heads up the Independent Women's Law Center, and Samantha Harris, who is a senior fellow at the Foundation for Individual Rights and Education, as well as an attorney working on exactly these kinds of campus discipline issues for Mudrick and Zucker. Ladies, thank you so much for making the time today for this chat and talking about this important issue, which I think it's especially cool that we have three women here to talk about this issue because it is so often framed as an issue about protecting women.
Thanks for having us, Inez.
Thanks for having us.
So Samantha, could you kick us off by talking us through exactly what changes this new rule actually makes for how colleges and universities handle sexual assault cases? How did they handle them before? And then what does this new rule actually demand? Because I think there's a lot of articles and opinions flying back and forth and your hot takes. What does this rule actually do?
Yeah, so I mean, to answer that, it's worth sort of starting with, as you said, a discussion a little bit about how things were being handled. In 2011, the Department of Education under the Obama administration issued a guidance letter. It was called a Dear Colleague letter that just absolutely transformed the way that campuses handled sexual misconduct adjudications. The letter itself had some prescriptions that reduced due process protections for students. It required schools to use a low preponderance of the evidence standard, which is the lowest burden of proof in civil law. And it also discouraged schools from allowing the parties to directly cross-examine one another. But you got to put that against the backdrop of the fact that virtually no schools allow advisors to participate in the proceedings. So what that ultimately resulted in was just virtually no cross-examination being allowed whatsoever. And at the same time as they issued this letter, they also just ramped up investigations of universities. Over a period of 3 years, the number of schools under investigation for Title IX violations quadrupled. And so you had this climate of fear where schools were, in addition to the sort of prescriptions that the Office for Civil Rights set out, schools were just sort of racing to be seen as, aggressive on sexual misconduct. And in trying to be seen that way, they just sort of abandoned procedural protections left and right in an effort, honestly, just to make it easier to get findings of responsibility in these cases. So you had a system where a lot of schools had honestly dispensed with hearings altogether. A lot of schools handle these cases right now under what's called a single investigator model, where you have just one person who's sort of acting as detective, prosecutor, judge, and jury. The parties may never have any opportunity to cross-examine each other. They may have no opportunity to see all of the evidence. Sometimes they're just given a summary of the investigator's findings as opposed to the actual evidence that the investigator relied on or reviewed. And so these regulations change all that. Under Title IX, adjudications of sexual misconduct grievance procedures have to be both prompt and equitable. And what's happened is that these have become very, very inequitable. And so what the regulations do is they require procedural protections that are going to guarantee a more equitable process. They require, and we're talking about for universities here, things are a little different in the K-12 setting, but at universities, they require live hearings with cross-examination through an advisor. Parties aren't allowed to do the cross-examination themselves, but advisors have to be allowed to participate for that portion. They require detailed written notice of what a student allegedly did wrong. I mean, you wouldn't believe how many students have been called in to interviews having learned nothing more than you've been accused of violating your school's sexual misconduct policy. And then they're called in to start answering questions. So now they have to have details not only about the policy that they may have violated, but also about what they did that may have violated the policy. They have to have access to all of the evidence relevant to the allegations. So they can't just see what the investigator or adjudicator ultimately decided is relevant to the case. They have to see all of the evidence related to the allegations, because there might be things tending to prove guilt or innocence in there that the investigator didn't use. Schools are also required to use unbiased training materials. Now, this is something that has been a huge problem over the years. We know that schools are training their Title IX panels using materials that rely on sex stereotypes, that encourage the panels to overlook inconsistencies in parties' narratives. And schools have been very, very secretive about this. I mean, the only way we know this is materials that have been obtained either through Freedom of Information Act requests or through litigation discovery. But now, in addition to requiring unbiased trainings, the department is going to require schools to post those training materials on their websites. Now, something we can talk about a little later is I'm a little concerned that that's just going to sort of shift the worst of the training out of written materials and into what people are sort of just told in these trainings. But, these regulations, transparency, from the notice to the live hearing to the training materials, transparency is one of, I think, the really consistent themes throughout these regulations, and one that's really important. And of course, it's a huge document. There's a lot to unpack in there, but assuming we want to, get to some other questions, those are some of the highlights.
I wonder if maybe because you work on these kinds of cases, both for the law firm and at FIRE, you also were involved in some of these cases. I wonder if you might tell us, how these rules prior to this new set, so from the Dear Colleague letter in 2011, how universities' procedures for handling these kinds of cases impacted an actual person or one of these actual stories, because we know there are more than 90 wins in federal court over this, over denial of due process. There's hundreds of settlements, and that represents a small percentage of people who actually had the resources to go and take this thing to federal court. Could you tell us maybe one of the stories that in your background that you have learned throughout working in this very fraught field here?
Yeah, back in 2014, FIRE was involved in a case at Occidental College. And this was a case, as many of these campus cases are, that turned on, how drunk the parties were. Because it wasn't a question of whether there was force, it was a question of whether the female complainant had been too drunk to consent. And so, Occidental had this investigator conduct an investigation. The investigator reviewed text messages from the complainant to her friend or roommate that said things like, "I'm going to have sex now," and texts to the respondent saying, "Do you have a condom?" But the university still found that she was too drunk to consent. And they found this after a hearing at which he had no right to confront his accuser or question her story. And they found this using the lowest burden of evidence, the preponderance of the evidence. And this is typical. And I can say that, now in my private practice, having been involved in cases, because universities have different policies now, right? So I've been involved in a case where a university did allow for a hearing with cross-examination, and one where the university didn't, where it was just, the investigator conducts the investigation, you get the parties' written statements, you have a right and ability to respond to the written statement. And I can tell you there's just no contest in terms of the ability to get at the credibility, because in these cases, generally, there aren't witnesses. And so really they turn on the credibility of the parties. And it is just, there's no comparison in terms of your ability to investigate the credibility of the parties between when you're able to conduct a cross-examination and when you aren't. It's not even a close call.
I think a lot of people out there probably have that misconception you pointed to, right? That this is going to be an accused actually cross-examining his accuser. But as you mentioned, that's not the case, right? It would be through an advocate or a representative. And similar to, I think, probably for a lot of people, the only time they've watched this happen live, right, was in the Kavanaugh hearings, where the Republicans brought in a lawyer to ask questions about time and place and trying to. So that's what we're talking about here. It's not it's not an excoriation. It's basic questions about lining up facts and looking at a story with rational eyes and so I think that's really important to know. We're not talking about the person himself cross-examining, if that is something that the victim wants to avoid or the alleged victim wants to avoid, correct?
Correct. And in fact, that's something that has been clarified from the proposed rules to the final rules. I mean, if anything is clear from this 2,033-page document, it is that the Department of Education really took seriously the feedback from everyone it heard from. And in the explanation of the cross-examination provisions, it specifically addresses this concern that it could be traumatic to be cross-examined by someone who may have attacked you. Because of course, in a court of law, that can happen, right? You have the right to self-represent. But the Department of Education, in determining what constitutes an equitable procedure, really took that feedback seriously and said, we're not going to let parties self-represent for cross-examination. The advisor is going to have to do it. And the hearing panel is going to have to be trained on issues of relevancy so that only relevant and non-prejudicial questions can be asked, and that so irrelevant questions about, things like a complainant's sexual history can't be asked.
Jennifer, I want to turn to you here. Like, how did we get to the point where I hope you can't hear the truck? This is okay. Downsides of the age here.
Right.
But how did we get to this point, right, where we're talking about ignoring text messages after the fact, and we're sometimes ruining people's lives on a more likely than not a 50% plus one standard? I mean, these are things that seem so far outside the American tradition of due process and the presumption of innocence. And Title IX just says, quote, "No person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of or be subjected to discrimination or any education program or activity receiving federal financial assistance." How do we get from those words to the point where we were at with this 2011 Dear Colleague letter?
So you're right to point out, Inez, that Title IX is really a very simple non-discrimination mandate. And, lots of times I hear people say, oh, yeah, Title IX started off as a sports equity law. No, it didn't. And it didn't start off as a sexual harassment law either. It is a law that very simply says schools cannot discriminate on the basis of sex, period. How we got here, I think, is an interesting question. In the early 90s, there was a case that went up to the Supreme Court called Davis versus Monroe County. And that case posed the question whether schools can be held liable for the actions of students against other students. And in that particular case, it was a little girl who had been harassed on the playground by another boy in, I believe, her elementary school. And the question was whether the school district should be financially responsible for that. The Independent Women's Forum actually filed a brief in that case arguing that the school district should not be found liable because we anticipated what would happen if the court were to make such a finding. And in fact, the court did allow students to sue their school districts for peer sexual harassment. And the court tried to cabin its ruling on very narrow grounds. What they tried to say was, yes, if a school systematically ignores claims of sexual harassment or assault by female students, they are discriminating. And that's true, right? If a school deliberately ignores every girl who comes to them and says, I'm being harassed by this kid, you could say the school is deliberately indifferent to girls or women, and therefore they are discriminating. What happened, however, is that school districts and ultimately activists and officials at the Department of Education stretched that decision. And they stretched it to say, oh, a school or a college is going to be liable every time somebody is assaulted on campus. Therefore, we need to do all these things to make sure it doesn't happen. Or schools are going to be liable if they don't adopt these particular measures. So what started off as a decision saying schools cannot systematically ignore claims by women on campus that they're being harassed or assaulted turned into schools have to set up these tribunals and they need to prove that they're not discriminating against women by hiking up their quote unquote conviction rates. And so Sam is right to point out that under the Obama administration, the Department of Education issued this Dear Colleague letter which put many of these draconian policies in place. But it was happening before that. It started in the 90s, and the schools were under a lot of pressure from the media, from activists, from victims' rights groups to do these things anyway. And the Dear Colleague letter really accelerated that process and forced colleges and universities to adopt these rules probably more quickly than they otherwise would have, but they were headed in that direction, unfortunately.
Sorry, I've been muting my mic to try to keep the beeping at a minimum. So, given what you're talking about, the pressures that you just referred to, Jennifer, on schools, from internal pressure, from the fear of lawsuits, and from folks on campus or activist groups, what are some of those main critiques? You laid out the Davis versus Monroe. What they were worried about, right, is that kind of systematic ignoring of harassment. But what are some of the more modern or more current critiques of this particular rulemaking? So for example, a senior counsel at the National Women's Law Center said, quote, "We view these rules as requiring schools to use procedures that treat victims unfairly." We've also heard, of course, the language around, and especially with Joe Biden and Tara Reade in the news now, we've heard that language about believe all women. To what extent does the presumption of innocence, extend to men in these kinds of circumstances? And we've heard again that refrain: if you're silencing victims, or it's too difficult for victims to come forward, if we have these kinds of due process safeguards. Do these rules make it unduly hard for victims to come forward, or is fairness served for everybody by implementing or keeping these kinds of due process standards? And that's a question for both of you.
So the new rules don't make it harder at all to report. In fact, they encourage reporting, and they make very clear that schools have an obligation to provide supportive measures for victims, even if they don't want to go forward with a complaint. So I think they encourage reporting in that sense, that the choice is really up to the complainant to decide how they want to proceed. If they just want to ask for schedule changes, or they want counseling, or they want to have support in determining what they're going to do, the school can provide that. They don't necessarily have to start an investigation of their own. I would actually like to ask someone from the National Women's Law Center which specific provision they feel is intimidating to women. Is it the fact that you have to let accused students see what they're being charged with? How does that intimidate women? Does it intimidate women to say that an accused person gets to essentially defend themselves and tell their side of the story? How is that threatening to women? I mean, the only thing that I think is even a legitimate concern, which Sam has already essentially debunked, is the concern about being re-traumatized with an aggressive cross-examination. But the rules make clear that we're not talking about cross-examination like you would see in court, and that schools can implement all sorts of rape shield protections. They can have the parties in separate rooms. They can, as you mentioned, Inez, have a third party ask the questions in a very sort of soft and deliberate way, like they did during the Kavanaugh hearings. So that is not going to be a re-traumatization of most people. And I think what the National Women's Law Center and opponents of these rules are really saying is that they think these rules are unfair because they don't automatically believe the accuser. And because that's what they really want. They want anytime somebody brings a claim that person's believed and the accused is punished.
Yeah, I mean, I think, I want to add something substantive about the rules, but I think, you really are getting at something there, Jennifer. There are a lot of people who really believe, in the United States, one of the sort of fundamental principles of our legal system is this sort of Blackstone principle, which is that it's better that 10 guilty people go free than that one innocent person be wrongly convicted. And from having now sort of seen the responses on my Twitter feed and things like that, to these new regulations and to some of my comments, what I'm really realizing is not everyone believes that, at least not in this context. There are a lot of people who think, that you got to break a few eggs to make an omelet, that it is better. It's not a grave concern if students are found responsible who aren't responsible, so long as, we can find the truly guilty.
But I think in fairness, what they would also say is this isn't a criminal proceeding and nobody's liberty is going to be taken away.
But they've never seen the impact on the life of someone who is found responsible for sexual misconduct, who can't get into another college, who can't get a job, who might be depressed and suicidal. I mean, it is not a criminal proceeding, that is true, but the consequences are severe. And as a lot of courts have recognized, finding of responsibility for sexual misconduct, it's not like a finding of responsibility for plagiarism. It carries a really serious lifelong stigma. The other thing I wanted to add about, why these regulations I think are actually encourage reporting is that they explicitly allow for mediation. Under the 2011 Dear Colleague letter, the Office for Civil Rights had said that mediation is never appropriate in cases of physical sexual misconduct. Now, that's something that the department, when it rescinded the Dear Colleague letter in 2017, it made clear that even under its interim guidance, that mediation was permissible. And in fact, a lot of schools began introducing mediation because you have a lot of complainants. I mean, if you talk to university attorneys, a lot of them will say that the mediation is a good option because there are a lot of people who come forward who may feel like something happened that wasn't right or that shouldn't have happened. And they want some sort of mediated conversation or some kind of reckoning or of some sort, but they don't necessarily want to see the other student suspended or expelled. And so, not only is this beneficial to respondents because, where previously the only option might have been a formal hearing resulting in suspension or expulsion, it also benefits complainants because it encourages them to come forward even if they're not looking to go through a full-blown judicial process.
It also benefits them in another way, and that is, when these decisions are being rendered without due process, and when the public starts to believe that these decisions aren't fair, that hurts survivors. And it also hurts them if they've been assaulted and then the case goes to court or it gets appealed within the university and it gets flipped because there were due process violations. That doesn't help a complainant in any way, shape, or form. So actually, by attempting to preserve the integrity of the process, it actually is a benefit to complainants.
Absolutely.
I couldn't agree more, especially with those larger consequences in terms of ironically, I've often thought that the Believe All Women mantra is actually cutting against the ability of victims to be believed, especially in ambiguous situations, right? When we expand also the definition of what is considered assault or harassment, when what people have in mind is one of these cases like Samantha, you describe at Occidental, when you say I was assaulted, that's a very different picture than people might have had in their heads, 10, 15 years ago. And it goes to larger cultural credibility of somebody coming forward. And I think that's been really negative. And then on the flip side, of course, IWF conducted a poll during the Kavanaugh hearings and found that 60% of men would rather be accused of murder than sexual misconduct, right? Because you would think, okay, one is much more heavily punished, but on the flip side, they felt much more confident they would get a fair hearing if they were innocent of a murder than they would if they were accused of sexual misconduct.
That's really interesting.
That really highlights how how people see the unfairness of this process and how it affects how they think about sexual assault and victim stories altogether. So I want to turn to one last thing before we look to wrap this up. I think we've talked a lot about the human toll on both the accused and the accuser's side here. How can we ensure that these protections, these due process protections, which Jennifer, you just so eloquently put, they protect everyone? How can we ensure that universities are actually going to implement these protections? Because I know in the First Amendment context, we've had quite a few victories. Samantha, I'm sure you know, in the First Amendment context, FIRE has had victory after victory in the federal courts saying, no, universities, you have to uphold these obligations you have under the First Amendment, public universities. And yet they'll go right back after settling and change a word or two of their policy, and they will continue violating students' rights. How can we ensure that this doesn't happen, and that these new rules are actually respected by universities who often politically may disagree with the conclusions of the Department of Education?
I think it'll be interesting to see what universities do. I have 2 daughters in college, and we've already gotten copies of the letters that they sent out, essentially saying, they're going to review their policies, but of course our policies already comply with Title IX, and we'll see. So I'm not entirely sure that they are going to be eager to comply with these policies, with the new regulations. And I do think that people will probably have to continue to bring lawsuits to vindicate their rights. And that's what we have Samantha for.
Yeah, I mean, my one-word answer was going to be vigilance, because, this is not a time, I mean, even assuming, and we're not even, I mean, we could get into the fact that any day now there are going to be at least, one, if not more, lawsuits challenging these regulations that we're going to have to fight back against. But, even, assuming the regulations are in effect and everything, we can't just, go, okay, our work here is done. Because, as you say, I think universities are going to fight tooth and nail on compliance, and we're going to have to be very vigilant, and we're really going to have to monitor. One thing I said at the beginning was, they have to post their training materials on the web now. So clearly the bad stuff isn't going to go in the slideshows anymore, but what's going to be happening in those trainings? We're really going to have to be paying close attention and not sort of rest on our laurels and think, okay, now that students are entitled to due process on paper, they're going to be getting it in practice, because that's one thing that, we've seen at FIRE time and again in the free speech context. And I see Nikki Neely from Speech First out there watching. So hi, Nikki. I know she deals with this too, is that, a school can have the greatest written paper, a written policy on free speech, but they have to apply it in a way that's constitutional too. They can't, have it on paper and then deprive students of their right in practice, which is something we see all the time in the free speech setting. And we're going to have to be very vigilant, just as after speech codes started to be declared unconstitutional in court, a lot of schools got rid of their written speech codes, but still maintained policy practices that violated students' free speech rights. We're going to have to be very vigilant for that in the due process context as well.
One thing that's interesting, everybody's acting as though these new rules are so controversial. They really just codify what the appellate courts and the district courts have been saying when students bring these cases, which is that they're entitled to a certain degree of a fair process. And, when those cases come down, when courts rule in favor of accused students, it's not as if the universities go running back and say, oh, whoops, let me adjust my policy. No, they don't do that. They quietly settle the cases, and then they continue doing what they're doing. And so, to the extent that these rules simply codify the rights that people are entitled to anyway, people are going to have to continue to fight for those rights and enforce them in court. But, to Sam's point about vigilance, hopefully there can be some degree of shaming involved here where, the universities are at least embarrassed about what they're doing, and and there's a national discussion about the right to fair process, and there can be public pressure.
Yeah, and I got to throw in a little plug for FIRE's annual due process report, because we actually look at the top 53 because there are ties. It's really the top 50 schools in U.S. News and World Report, but there are ties, so it's 53 schools. We look at their due process protections, at their policies, and how well they comply with a whole bunch of important due process protections, many of which have now been codified in the regs. And so, we will be continuing to publish that report and be taking a look at whether schools are complying. So.
Okay, well, I will be looking for that report. Thank you so much to both of you for sharing your expertise with our audience here. And thank you, audience, viewers out there, for bearing with our tech issues and interruptions. But I'm so glad that you tuned in to hear these two accomplished women talk about this very, very important issue and these Title IX regulations that have been so much in the news the past 2 days. Ladies, thank you both. This is Independent Women's Forum. I'm Inez Stepman. Thanks for tuning in.
Thanks. Bye, Inez.
Bye. Thank you.